Welcome to Your Need to Know. I'm your host, Catherine Reed, and tonight we're going to be talking about legacy planning with Bettina Lawton, Esquire of Lawton Legacy Planning here in Northern Virginia. And thank you so much for taking time to talk with us tonight, Bettina.
Absolutely, anytime.
And what prompted this is I got an email that the Fairfax County Public Library was actually sponsoring a presentation that you're giving on the 16th of April about legacy planning. And I reached out and said, "Hey, the Fairfax County Public Library is sponsoring this, and what a great idea." And you informed me that this isn't the first time you've done this for the library. It's not the last time you're doing this for the library. It's just the first time it's been on my radar. And I wanted to share this with our viewers because legacy planning is so important. And you did my legacy planning. It was a great experience for me because you walked me through, and this is really kind of, I have to say, the first time I've done this way, because as a single divorced mother of three, I had done some, cheap legal Zoom, downloaded off the internet so the kids are not left with no will, sort of thing. But I'd never actually, since getting remarried, which is a triggering event. We should tell people that when you get married or divorced or have kids, these are all things that should prompt you to go, what about my legacy planning? It's the first time I'd ever done it. And so I was remarried. My kids were adults. And you really walked me through thinking about so many things I had not thought about before, including it's not just about somebody dying. I mean, we think about a will and it's like somebody dies, but people are also incapacitated for a very long time. And I had never considered what would happen if my spouse was incapacitated or what instruments I would need. So I just want to let our viewers know that, legacy planning isn't just a will.
No, it's not.
So talk to a little bit, you're an attorney, you've been an attorney since 2003, you've been doing this particular
since 2003.
So what made you choose this as your niche legal practice?
Well, I was doing something different for a number of years before that. I was defending people being investigated by the federal government. And so when I decided I wasn't going to do that anymore, I thought about what did I want to do? And my father had what I would call a bad death because his documents were done. They were done by an attorney, but it wasn't somebody who did estate planning, which is a huge difference. You don't want to go to somebody who is sort of a general practitioner or a real estate attorney or a family law attorney. If they don't do estate planning, they're not necessarily going to understand the consequences of some of the things they did. And this fellow, this attorney, is a great guy. But when my father came up with a way of having his advanced healthcare directive done and the agents done, there were 3 kids at the time in our family. And he decided that he was going to have all 3 of us make a decision. But my brother had to be in the majority in order for it to work. And the lawyer didn't say to him, "Jack, this is a bad idea. Don't do this." And when he ended up in the ICU and he ended up on life support, we couldn't do what he wanted done because the hospital would just not follow it. Even though my brother was in the majority, the hospital was too worried about being sued. And so they wouldn't do it. And my father ended up being on life support for about 14 days. And our family split up for a number of years. I mean, it was just ugly. And I thought to myself, if I can get at the front end and explain to people, here's how this works. This may sound like a great idea, but here's how it works in real life. And one of the things that many people will say to me when I give talks is that they'll say to me, "You don't really say that to your clients, do you?" And I'm like, yeah, because what's the point of not sharing what you know, either from your own life experience or from the accumulated experience over the last, 17, 18 years of my clients? And how does that work? How does that piece of paper that you put together actually work? And so that's really what I got into this for, and why when I take people, as you were saying, when I take people through the process, we have the conversations that say, if you don't have a will, at the end of the day, what do you care? You're dead. right? Nobody's going to be happy with you because you've left a mess, but you're not there to have to experience it. If you don't have the disability documents, which are the financial powers of attorney and your medical directive, in some places that's called a healthcare power of attorney, you're alive and everything is going bad. So you really want to plan for disability, have those documents, plan for your death, so that when you die, people aren't just cursing you out because you left a mess. They actually are just grieving the fact that you're gone. You want to do that whole thing because you want to make it easy for people to help you when you're alive and to do what you want done after you have passed. And as you know, the mortality rate in Virginia is 100%. It has always been 100%. It will always be 100%. We are not getting out of this alive. And so you want to plan for what's going to happen. And that's really what I try to do with my clients, is talk to them about that. One of the things that people need to realize as well, and you were talking about, you had done a plan early on when your kids were minors, which is essential. If you have minor children, you've got to plan. Because who's going to take care of them? You don't want them to go into foster care while some judge sorts out who gets to take care of your kids. So you have that sort of life experience. You can't just put these documents on the shelf and leave them there. You've got to go back every 3 to 5 years. Take a look at your life. Take a look at your beneficiaries. What about your agents? If you've named somebody your age or older, are they still in the area? Did they downsize and move someplace else? Are they mentally and physically able to do what you need them to do? So you don't want to put this on the shelf. You want to keep rethinking about it. You want to think about what you're doing. If you move, you want to make sure that the options that you had where you lived before are still going to work where you are. The example I love to give Catherine about this is, if you live in DC, DC has a death with dignity law. All right. Virginia does not. So if you have a medical directive premised on the fact that you lived in DC and you move to Virginia and you don't update it, you're going to be thinking, your agent may be thinking, oh, you know, when mom gets to this stage, here's what we do. We go to doctors, we do this and that. And then mom gets to control how she passes. No, you're living in Virginia now. Virginia law is going to govern this. It doesn't matter that that was good under DC law. That's not our policy here. That's not our law. That's not our public policy to allow that. And so you want to always have something reviewed if you go ahead and move jurisdictions to make sure your options are available. The documents are still good because this is the United States and the federal Constitution says it will be all good. But you may be under a misunderstanding about what your rights are and what your options are. Because in the reverse, if you moved into DC from Virginia, you have more options, but your documents don't reflect that. And so you're not going to be able to take advantage of it necessarily. So you really want to keep up on these kind of documents. The laws change, your life changes, you want to make it work together.
Well, and you make a good point about death with dignity laws. I personally think Virginia needs to catch up. There's very few states that have them. Yep. My sister went through a very interesting certification program through the University of Vermont to become a death doula. And this is also becoming something that more people are taking advantage of, is choosing how they will depart. But you have to be in a state that allows for that. But, you know, even something even more minor, one of the things that you had me do that I loved was putting an appendix to my will that allowed me to decide what my children can have or what I want them to have so that they don't fight. And let's face it, so many families have split over who gets a piece of furniture or the silver, or too many families have been split up over people fighting over stuff. Right. And so you made it clear to me, you got 3 kids or, you know, siblings, you know, if you want somebody to have something, state what it is. But instead of making that part of my will, here in Virginia, we have the ability to have this document that can be changed right up until the day I kick the bucket. Right. That's not true in every state, but something that minor means that my children can hate me for giving the wedding portrait to the oldest, but they're not going to hate each other because I decided.
Right. Exactly. And that's called a personal property memorandum is its technical name. And it's in the statute. And it says if you have, it's tangible personal property. So I say to people, it's your stuff. It's the things that don't have titles. It's the family photos. It's your furniture. It's your pictures on the wall. And it's a document that says you have to refer to the will or the trust. It also works for revocable trusts. But it's not part of the document. You don't have to have it witnessed. You don't have to have it notarized. All you have to do is describe what is that item. And you have to do it with some specificity that there's no question. So if you have 2 strings of pearls and you want to give 1 string to each daughter, you have to be able to identify from how you described it, or you could take a picture and attach it, which goes where. So there's no ambiguity, which daughter gets it. You sign it, you date it, you keep it with your will and your trust. Don't stick it in the drawer in the kitchen with the junk stuff, right? It has to be with your documents. And that governs. And then as time goes on and your one daughter is like, I'm really not a pearl kind of person here, but I really love that funky Art Deco kind of necklace. How about I get that? You can just go back, make a copy of the blank, because in my binders that I give to clients, I give them 2 sets of it so they can just copy it again. And put in the funky deco necklace and take out the pearls, sign it, date it, stick it all back in again, and you're good. You don't have to come back to a lawyer. You don't have to do anything extraordinary. Sign, date, keep it with the documents, people.
Exactly. And I loved 2 things you pointed out there. You gave me a binder that had sections that were marked for things like a durable power of attorney, for a medical directive, for the will, and for this personal property addendum. And so, and my husband knows where it is, and my kids know where it is, and it's all neatly laid out and clearly labeled. Right. And something else to point out about changing that personal property at the back is when you have grandchildren, which we are now in a position where we have 1 and we're expecting a second one. And so the pearls may end up going to the granddaughter,
right,
instead of the daughter. And so you don't think about that, because none of us sit around thinking about our impending death. Let's face it, nobody wants to think about that. And yet you're not doing this for you. You're doing it for your family. The last thing on earth is that my children to not speak to each other or to have hard feelings or bad feelings because I made a mess of telling them what I wanted done with my property, or selling the house or all of those things. So we're going to go to a short break. I hope all of our viewers are going to stay tuned, because this is really important information. And Bettina's going to help you think about things you never thought of either. And again, it's really not about you. Being dead is fairly easy. It's really about what you're doing so that your family is left behind with something that they can work with. So join us after the break. You're watching Your Need to Know here on Fairfax Public Access.
Caitlin, be serious. No, take the oath. Come on. I'm totally taking this seriously. Okay, I'm ready. You may begin. I pledge that I will never meet in person with anyone I first met online without checking with my parent or guardian. And furthermore, if my parent or guardian agrees to the meeting, it will be in a public place and my parent or guardian must come along. Do you pinky swear? I do.
When you teach your kids about internet safety, they'll pass it on. For more information, go to cableclicksmart.org.
You ready for the surprise?
Yeah.
Resuming moments like these starts with protecting our kids against COVID-19 and dangerous new variants.
Oh, you miss him.
Get the latest facts by visiting getvaccineanswers.org and speaking to your pediatrician or healthcare provider.
Your blood pressure numbers could change your life. Talk to your doctor about creating a plan that works better for you. Start taking the right steps at manageyourbp.org.
Freedom. It's at the core of who we are. The freedom to live without fear, to jog where we please, to wear a hoodie. The freedom to breathe. Before we celebrate the freedom most Americans have, we must fight for the freedom all Americans deserve. Because all lives can't matter until Black lives matter.
Welcome back to Your Need to Know. I'm your host, Catherine Reed, and we're talking about legacy planning here on Your Need to Know. And our guest is Bettina Lawton, who is an attorney here in Northern Virginia, who helped me with my legacy planning. And she's really trying to guide our viewers through some of the things we all need to be thinking about well before we get to what we think is the time of our life when we're going to depart. Because Bettina, we never know when we're going to depart. If we all think we're going to live to be 80 or 90, that's a wonderful aspiration. But the fact of the matter is, at any age, any of us can be taken. And the question is, what did we do to make sure that our families are not left with this horrific legal and financial nightmare? But let's say we are going to live to be 80, and right. that we have certain kinds of goals, like I want to stay in my house. Mm-hmm. Part of what you have to help people understand is prioritizing what their goals are and what is feasible.
Yeah, that is a huge issue for people. And that is one of the things when we start planning, that's one of the first things we talk about is what's the goal? If you tell me what the goal is, we can try and work to figure out how do we achieve that for you. The issue, as you've just pointed out, is if your goal, for example, is you want to stay in your house. If something happens to you, you want people coming in, you don't want to have to go to assisted living, you don't want to have to go to a nursing home, this is what you want to do. And one of the things that COVID showed us was that if you can keep your loved one at home and take care of them there, you will frequently get a sort of a better kind of result for your loved one. And we saw in COVID a number of people in nursing homes who ended up dying alone because people couldn't get in. Well, even when people could have gotten in, a lot of people died alone because it was unexpected. Nobody knew. So it's one of those things. And that goal, the being at home, is something that a lot of people come in. And one of the things that I have to talk to people about is how are we going to make that happen? I've had clients who really loved certain property that they owned. They wanted to keep it in the family forever, you know, the cottage at the lake kind of thing, stocks that they loved. They didn't want anybody to, you know, mess around with this. They thought they were in on the, you know, new Google kind of thing. But if you don't give the authority, for example, to your financial power of attorney to sell that property, to trade those stocks, how are we going to get the money to keep you at home? You know, there are more complicated things like reverse mortgages and things like that that you can try. But again, that depends on your current mortgage, the value of your house, if there are expenses involved in doing those kinds of things, how fast can you get it done? So you want to make sure that if your goal, what is your goal? And then you want to make sure that all your documents, all the authority that you're giving people and the people you choose are actually able to do what it is you wanted them to do so that you get to your goal. Because that's what it's about. It's your goals. It's not what does your spouse say you should do? What do your kids say you should do? What does society say you should do? It's what do you want to have happen? Let's figure out how that can do. And let's figure out who can do it for you. So, you know, we were talking about the end of life scenarios and the death with dignity. Well, you wouldn't want to say, I want to take advantage of that in my state and then name someone to make those decisions for you who doesn't believe in that. It's either not going to happen for you or that's going to be a huge burden on the person that you named. So you have to align your goal with what the documents say and with who you're choosing to carry them out. And that's the kind of thing that you really want to have somebody talk to you about as you go through this process so that it does end up with you getting what you want to have happen.
You know, and you point out something. I have 3 children and my husband, Tom, has 2 children and one of his children lives overseas. And so when we were doing our wills and trusts and these directives and durable powers of attorneys or medical directives, I had to pick one of my 3 and get her to agree and then explain to the other 2 why I had chosen her. And Tom, I mean, his son understands he's the one over here. But we each spoke to our children, not just about the fact that it was a tremendous burden that we were placing on them, but they agreed to that and understood what we were asking them to do. And then we shared the documents with each of them. So they have those documents. And I just think that's absolutely necessary. If you want to do something for the family you're leaving behind, you need to be clear, and they need to be told ahead of time, and they need to agree.
That is so, so important. The number of people who, when they say, oh, I want, this child, or I want my sister, and I'll say, have you talked to them? Well, no. Well, you got to get them to agree, and you've got to make sure that they understand what you want done, and sharing the documents, having the conversations. I will tell you, the medical directives are typically the most emotional and the most difficult one for clients to deal with, because many people's kids are like, I don't want to talk about that. Oh, that's icky. I don't want to do that. One of the things that I give to clients is a little book, and you can actually get it on Amazon, but I give it to my clients. It's called Hard Choices for Loving People. And it was written by Hank Dunn, who was a chaplain for hospice, Nova Hospice. And what he found was that a lot of people who were trying to communicate what they wanted done didn't understand the choices when you are at the end of life are different, and they have a different result than if you don't have any comorbidities, you're expected to recover, those kinds of things. And that the people, the agents who were chosen to carry these things out don't understand either. And so some of the things that he does, it's a little tiny book. A lot of the things that he talks about, for example, are the artificial feeding and hydration. Oh, I don't want mom to be hungry. I don't want mom to be thirsty. And they don't realize that you're not. If you're at that stage of life where death is coming sooner rather than later, that's not part of what happens when your body starts to shut down. And so those things, that sort of educational thing, and talking to people about what do you want, and not just with your agent, because you do not want to say to the child you named, here's what I want. They understand. Everybody's good, right? But your other two children are in the hospital yelling, you're killing our mother. You want to make sure that everybody understands what it is you want, and that it is your choice, because that is the goal. It's your choice. It's helping you figure out what do you want, and then making sure that it happens.
And this is why people need to consult with somebody like you who knows all of this and can pull it all together. A lot of people are like, well, I have a will. Talk a little bit about why often wills and trusts are put together, because they're not the same thing.
Oh, they're not the same. And if you have kids, for example, you want to have a trust. It's a revocable trust during your lifetime. You title your assets into it, and then you run it just like you would have if they weren't in the trust, right? If you want to spend money, you spend money. You want to sell something, you want to buy something, you just do that. But then if you become disabled and your children are still minors, you have named in that document a successor to do those things. They're called trustees. And that person just steps on up. There's no court involvement. You're not filing a probate. You're not waiting to get that appointment with the court, right? Your successor trustee, you're disabled, you're unable, you're still alive. You're not able to make these decisions to take care of the financial end of things for your kids. Somebody's there, and you've named them. The court hasn't named them. And so the trust does that. A will doesn't take effect until you're dead. So it doesn't matter if your will says, these are the guardians for my minor children. You need to be dead for that will to be probated and for that to happen. If you have minor children, I always say to folks, you really want to consider a trust. And you also want to do, in Virginia, we have something called standby guardians. And you want to designate those people. There's no form. You can't go on the internet and pull up the standby guardian form for Virginia. It doesn't exist. There's a statute. And the statute says, here's what you need to do. And so those are the things that I say to people who have minor children is, here's what we need to do. Let's think about who is going to take your kids. It would be, and I actually had a case with a client where she had, I think, like 3 kids. Her sister had 5 kids. Her sister lived on a farm, in like Pennsylvania someplace, right? She goes, oh, I'm sure my sister will take my kids. And I looked at her and I thought, that's 8 kids altogether. And I said, you really need to talk to your sister. And of course, the sister came back and said, my hands are full with 5 kids. There is no way I can take your 3. So imagine the mess that we would have had if she hadn't talked to her sister to find out that her sister was already topped out. So you want to do that, and you want to name who is the standby guardian. Standby guardianship, the designation that you do yourself, you don't have to involve the court in it, is good for 30 days because the court ultimately has to say these are the guardians of your minor children. Now, if you're married to the person, to the kid's husband, to the kid's father, that's going to be the guardian. And if the father, even if you're divorced, unless something came out in the divorce decree that says he doesn't get any kind of custody, he's still going to be the default. So you have to have both of you for your standby to come by, but that's where your trust comes in, because many people recognize, yeah, okay, the father of the kids are going to end up with the custody, the physical custody, but they don't want him running the money. They don't want him doing that. And so you can split that responsibility. The kids go to the other parent, if the other parent is still alive, but someone you trust and who understands your focus, and it's in the trust. You can put in the trust that says, here's what I want. You know, education is the most important thing for me. So I really want the trustee to manage this with an eye towards getting all my kids educated. You know, you can actually put in, and I've put it in, where people have said, I don't want my children's other parent involved in these decisions because the judgment has proven to be faulty over the years. I mean, you get to say those things. A trust is not a public document. A will is a public document. And so you want to set that up in a way that actually works. And with minor children, you really need that. If you don't have minor children, like I have a trust, I've had a trust for years and years. So if something happens to me, all my assets are in that trust. They're all in a bucket already for somebody to manage for me. They don't have to run around and try and figure out where's my bank account, what am I doing? It's all in the trust. And the binder, you referenced the binder that I give to people. The binder has everything in it. So it has all the stuff in it that says, okay, Bettina's bank account is here, and here's the account number. And I also started putting in like the title to the car is there. The title to my RV is there. I started collecting things like, because you need them for your death certificate. You need information about your mother. You need to know these things. So I have the death certificates for my mother and my father. I've got birth certificates in there. And
I want to say we've got 30 seconds left. And if you are interested in what Bettina had to say, go online and sign up for this virtual event Saturday, the 16th, through the Fairfax County Public Library, where all of your questions will be answered. Thank you so much for being here, Bettina. And this is what you need to know.